Okay, as I say, this is just an introduction to the legal system in Canada, and here's essentially what we're going to be looking at in this unit. And this unit is the foundation for everything we're going to do. Okay, the very first thing, we're going to define what the law is. What exactly is the law anyway? And as that being the pie, the slice of the pie that we're looking at in this particular course relates to business applications of the law. Okay, so the law is a very big thing. We're looking at the components of the law that particularly apply to business. That's our focus. The other thing we're going to look at is this issue of how does the law apply to ethics and business ethics. Business ethics, as I said in several courses, business ethics has become a big issue in business, doing the right thing. However, we have to distinguish between law and ethics in that the law is not necessarily ethical, and ethics is not necessarily the law. The two are mutually exclusive. Oftentimes the law mirrors ethical behavior, but no guarantee of that. So what's right and what's legally right may be two different things. We're also going to look at some terminology with regards to these slices of the pie that make up the law. You know, as I say, we're focusing on business law, but even within business law, we have to be familiar with terminology. First of all, we're going to look at what the focus of our course is going to be is something called the common law. And we're going to look at another thing called civil code, and I'll get to explain those in a few minutes. What we're generally not going to be focusing on, but we're just going to introduce or we're going to explain is this concept of criminal law. Criminal law is what we see a lot on the news, what we see a lot in television, in the media. Criminal law relates to people breaking basic rules that cause harm to others, okay? So for example, a murder, or someone speeding, or someone, not all of those things are business related. They could be, but when we're talking about the law that we're talking about in this course, we're talking about something called civil law, and civil law relates to operations within society, people's interactions within society, and wrongs that they do to others. It's not necessarily criminal acts. So, for example, if you come to my house and you slip on my bridge, my step, that's not criminal. Okay, I didn't do anything to harm you there, but you did get harmed. So you could sue me for damages, my insurance company for damages, but it wouldn't be criminal. It would be a civil action, what's called a civil action, and that's what business is mainly focused on, is civil actions. We're also going to look at this concept of statute law, and we'll get to that in a few minutes. Statute law is basically government-made laws, and administrative law, which is the operation of the legal system. So we're going to explain all that in this concept of the sources of law in Canada, where law comes from in Canada. We're going to look at the Canadian Constitution, and we're going to look at how that impacts laws in Canada. And the Constitution can be broken up into several parts too. We could think of the original Constitution Act that formed Canada back in 1867. It was called the Constitution Act, 1867, got a great name. We got the Canadian Constitution 1982. Back when I was in school, that was a big thing. The Constitution of Canada was originally held by the British Parliament, and which was interesting, seeing we were a country that was 100 and some odd years old and is like someone else was in control of our destiny. So the original Trudeau Prime Minister, Pierre Trudeau, made it his mandate to bring the Constitution home. So back in the early 80s, for those of us who can remember that, that was a big thing in the news. And in 1982, there was an agreement that excluded Quebec, but there was an agreement to bring the Constitution home. And in April of 1982, the Queen and the Prime Minister at the time, Pierre, sat down and signed the Canadian Constitution. That Canadian Constitution of 1982 brought with it a component called the Charter of Rights and Freedoms that never existed before in Canada. And that Charter of Rights and Freedoms has had huge implications for business, particularly from a human resource point of view, and we'll take a look at that throughout the course. we're going to identify and discuss the classifications of law, and we're going to explain the Canadian judicial system, how the judge system works here in Canada. So starting off, to start with, we need some basic definition of the law. So the basic definition of the law is a body of rules. That's effectively what it is. It's a rules. It's what you can and can't do, what you must and must not do. And it's made by a very important body called the government. Now, if you've been watching what has been going down in the United States, you know, that is so rare and shocking, because in our democracy, be it the United States, Britain, Canada, all the civilized world is democratic. What we mean by democratic is that the people, you, me, people who can vote, choose the government. Every 4 years, every 5 years, depending on where you are, we get to choose who represents us. Okay, who represents us. That representation then is reflected in the decisions that are made. So we elect a government. The government is what's called duly elected. It is legitimate in terms of our Constitution. That government then has the right. We have empowered them with the right to make laws. So government ultimately is the lawmaker in this country. Government can make the laws, they can change the laws, they can erase the laws, okay? To a certain point. And the thing is, when those laws are made, they need to be enforceable. So what the legal system does is it works on the enforcement of those laws. So government makes the laws, the legal system's job is to enforce the laws. And so the courts are the component of the legal system that ensures that the laws are being followed and that people are being treated equitably. So it's kind of a balancing act, you know. The government makes rules and regulations. The legal system enforces those rules and regulations. And the court's job is to rule, to say, first of all, is the law valid? Did it create undue hardship or break someone's other rights? Did it tramp on other people's rights? And just to bring some sort of, I'll call it equity, to kind of take the edge off some of these laws. Take, for example, here's a simple example. Government makes a rule that says that you have to be at least 6 feet tall to serve in the Royal Canadian Mounted Police, which is a government agency. Okay, so they made a rule that you had to be 6 feet tall and a man. Let's add 2 components too. So you had to be male and 6 feet tall. And that rule did exist. Many years ago, that rule did exist. You had to be tall and you had to be male to be in the RCMP. The courts have been asked to rule on that. And over the course of the years, the courts have found that those types of rules are stupid and not equitable. In other words, women should be allowed in the RCMP. People who are shorter, people's height has no bearing on their ability to enforce the law as a police officer. So what we see the court's job is to look at laws and say, do these laws really reflect what they should reflect? So it takes the edge off some of these laws. You know, they were put there with good conscience, but in the meantime, the court's job is always to analyze it. And as society changes too, we see courts changing. So the legal system is critically important as a component of our government, because what that does is government, duly elected government, make the rules. The court system look at the rules and say, how can they be applied fairly, equitably, so that everybody's rights are maintained within this overall body that we call the Constitution. There's all kinds of categories of laws out there. And again, we're only focusing on a slice of it, but just some of these terminologies that we should be familiar with here in terms of laws. First of all, there's something called substantive law. And substantive law is the bulk of the system. and it effectively lays out the rules determining behavior. Okay, you can do this, you can't do that. And we accept that in society. For example, there are speed limits on the highways. Substantive law would say that, okay, these speed limits are justifiable because if people are driving all over the place crazy, people are going to be killed. So there is a set of rules that say the Highway Traffic Act, for example, that is put in place by government, specifies that roads can have limits on how fast people can drive on them. So the Trans-Canada Highway, for example, 100 kilometers an hour in most of the Trans-Canada. Okay, so that is an example of substantive law. It's a rule that is in place for people's own good. That's public. We could also have substantive law, what we call private. So you and I have a contract. I agree to shovel your snow if we get any snow. So you and I have an agreement. I say to you, I will plow your driveway or shovel your snow for $20. And you say, yes, Paul, that's good. You shovel my snow, I will pay you $20. I go shovel your snow, you give me $5. I say, that's not our agreement. You agreed on $20. So I'm going to take you to court. I'll use the court system to settle this dispute that we have over how much. Okay? The court system is set up, and there are a bunch of rules in place in terms of fairness and equity, and in terms of business dealings, and there's all kinds of rules. That's just between you and me, though. That's an example of what we call private law. It's not much different, but it's just between individuals as opposed to society at large. Okay. We also have something called procedural law. And procedural law is how the laws need to be applied. It is the procedure for how the legal system works, as opposed to the laws themselves, okay? So it's rules outlining how the legal system works. And as I said to you, public law really regulates the relationship in the public realm, and that is everybody. So laws between us, the public, government agencies, and the like. And private, or what we call civil law. Now, it's confusing because I'm going to talk about civil law and I'm going to talk about the civil code. Okay, civil law is different than the civil code. Civil law is just the basics of business law that we're going to deal with, the relationship between individuals. Okay, regulates personal, social, and business relationships. Okay, so this idea of you slipping and falling on my step, that's an example of civil law. Okay. We also have international law. We're going to take a little look at international law, not too much, but effectively, if you're a business here in Newfoundland and you want to do business in Ethiopia, whose laws are applying? Is it Ethiopian laws? Is it Canadian laws? So this idea of how the legal systems work across borders is what international law deals with. In Newfoundland, we're probably most exposed to the international law in the fishery and the oil and gas. Where it's off the coast of Newfoundland, a lot of it is in international waters. So how do we arrange that and make the legal system work for that? Okay. If we had to look at law and we said we're at the 10,000 foot level, and we said, where do all these laws come from anyway? Where are the basic sources of law? Depends on what textbook you look in. So sometimes there's 3, sometimes there's 4. I put 4 down here, but 3 and 4 on my list are the same. So if you got some books saying there's 3, it's because the 3rd and 4th one are combined together. That's all that means. So effectively, laws come from 3 major sources or 4 major sources. Depends. The first one is government-made laws. Government-made laws are laws that are duly elected officials put in place. Let's take, for example, yesterday I had a meeting. I had a meeting of our recreation committee here in town. Now, if you live through the 1st of January, you know that there was fireworks going off all over the place. And we had a lot of complaints that people were shooting off fireworks at all hours of the day, night, for the 3 days before and the 3 days after. And not only has Clarenville dealt with this issue, but St. John's, Bay Roberts, every town in Newfoundland is dealing with this. Okay, so as a government of the town of Clarenville, which is a subset of the provincial government, we are looking at coming up with some rules that say that you can't shoot off fireworks at any odd time. Okay, we're toying with it. It's nothing really happening yet. That's an example of a government-made law if it comes into place. What we have is a duly elected government, and the duly elected government has the right to create laws. And in the case of a town, it's a bylaw. In the case of a provincial government, it is a law. In the case of the federal government, it's a law. And we'll look at the federal and provincial. As I say, towns are a subset of the province. They don't really exist in law, but it's provincial. There are two basic groups in Canada we're going to look at. We'll look at them in a few minutes, and that is the federal government and the provincial government. Okay, but these laws are duly elected governments making rules. Okay, they're called statutes. That's the name that's put on those rules. Now, we also have another system in Canada that is only found in the province of Quebec, and that's known as the Civil Code. Okay, not civil laws, but the Civil Code. The Civil Code comes out of Rome. It goes back forever. Many years ago, governments at the time, or the king or the queen at the time, usually a king, at the time recognized the need for laws. You know, we need to be able to, you know, if we look at the whole Christmas story, you know, why was Jesus born in Bethlehem according to the story? Well, the story was that they had to go back to Bethlehem. Joseph, Jesus' father, had to go back to Bethlehem because they were doing a census. The government of the day said that every man had to go back to his hometown. Women weren't really people back in those days, so every man had to go back to her hometown. So Bethlehem was the hometown. So they marched into Bethlehem, you know, the inn was full and all that sort of stuff. But the fact of the matter is, that was a government-made law that they were following, and they ended up in Bethlehem because of that. So these government laws existed many years ago. One of the things that the Romans did, and later the French did, was to create a set of rules, and you could imagine it like a rule book. You can do this, you can't do that. If you do something wrong, here are the penalties for that. Okay, so you can imagine a very broad-based rule book. And that rule book was known as civil law. And that civil law was really one of the primary systems in Roman days and later adopted by the French. Well, when the French came and settled French Quebec in Canada, you know, the French part of Canada, that rule, that codified group of rules came with them. So today in Quebec, it's a holdover from years ago. Today in Quebec, the provincial government particularly follow what's called the Civil Code. And the Civil Code consists of a bunch of rules that judges will look at and assess a claim. So someone goes to court in Quebec, in provincial court, and says, I've been wronged. The judges go look at the rule book and say, well, what does the rule book say with regards to this? And the rule book lays out, okay, here's what's wrong with this. Here are the penalties for that, generally. And the judge's job is to read that rule book and to apply the rules. That's what civil code is all about. Effectively, it's a rule-based law. It works very well. Unfortunately, or fortunately, that's not the system we use in the rest of Canada. Okay? In the rest of Canada, we use what's called common law. Why do we use common law? Because it came from England. And if you consider the rest of British North America, Canada, except for Quebec, is very much British focused, right? So we're seeing the way that Canada was settled being applied in our legal system. So the common law is really what's used at the federal and most of the provincial levels, most of the territorial levels, all except Quebec. And effectively, the common law is an interesting law because it doesn't have a rule book. It just makes it up as it goes along. Now, that seems lackadaisical, but it's a system that works very well. I'll explain it more when we get into it. Part and parcel with the common law, or sometimes it's called judge-made law, is this idea of precedence. And I use the sloppy term of making it up as you go along, but it's not really the case. What happens in common law is that a judge is presented with a case. Okay, here's a case that the judge gets. Okay, something happened to someone wronged someone, and the judge has to make a decision of what the damages are, or what the decision will be, who's at fault, these sorts of things. Instead of a rule book, what happens in the rest of Canada is judges go back and look at previous cases. Now, it gets a little more complicated than that, but that's the basic gist of it, is that we use previous decisions in order to help guide us in current decisions. And the Latin name on that is stare decisis. Let's look at these in a little more detail. Okay, first of all, we got this civil law thing, and I've got the little map of Canada with the Quebec in red there. So Canada is a federal state. And what we mean by a federal state is that we have a series of provinces and a series of territories. Now, the only difference between a territory and a province is the amount of legislative ability of the legislatures in that. So it depends on how much leash they have in order to make their own rules, okay? So the territories do not have as much authority as provinces. But we can consider them, for the purposes of us, basically there's 13 jurisdictions across Canada that all exist semi-independently. Okay, kind of makes Canada kind of a patchwork. Okay, so you can imagine that different territories and different provinces will have different rules. But the way the Constitution is set up, that's what happened. So as a federal state, then, the federal parliament, which is based in Ottawa, the federal government, has a blanket authority for all of Canada. It is what is called the supreme government. However, the Constitution lays out, federal government, this is what you're responsible for, A, B, C, and D. And there's a bunch of things that are laid out in the Constitution that clearly indicate the federal government's responsible for this. So, for example, we look at the Constitution of 1867 when it was originally written. Communications is the responsibility of the federal government. So what does communications mean? Radio stations. Okay, let's look at a radio station or the internet or something like that. It goes across the country. It doesn't respect borders. That's federal jurisdiction. Federal government has absolute authority on that. However, if we look at Newfoundland and we say, okay, well, let's look at what the province of Newfoundland is responsible for. Well, obviously, the province was clearly granted the ability to worry about its highways, its roads. Roads, in the Constitution, it says provinces are responsible for roads. So the rules related to roads in this province are defined by the province. The rules related to communications are defined by the federal government. Now, 152 years ago, when the Constitution was written, a lot of the stuff that we see today were never conceived. Okay? You know, the Constitution used the word communications. And generally, there can be arguments to say, well, what is communications? What fits as communications? Now, some people will say, well, things are obvious, but not everything is obvious. And in fact, one of the problems with the Constitution in 1867 when it was written is it never clearly outlined labor. Labor was not clearly marked in the Constitution as being responsibility of one of those levels of government. And that has caused a lot of grief in Canada. It was up until 1924 when the court system, the federal court system, rule to say that labor is the responsibility of the province. And they had to look at the Constitution, interpret it, look at previous decisions. And labor was handed to the provinces just back then. So, you know, it took 50 years to figure that out. So because Canada has this different levels of government with different responsibilities, that makes it a little bit more complicated in Canada. We've added in this Quebec issue and the fact that Quebec uses a different code, and that makes it complicated even worse. So if you're a lawyer, you love it because, well, you know, there's lots of work for you because all these different jurisdictions. However, in most of Canada, the good thing is that most of us use the common law and Quebec uses the civil law. Okay. The civil code is really, as I say, a codified body of rules that was, you know, back in the Romans, Napoleon, all that. It is used by many countries. Usually these countries are French-based countries, okay? Provincial courts in Quebec use the civil code as a body of rules. The civil code sets out basic general principles that are applied to the court, to the problems they're addressing. In this system, the judge is not bound by precedent, but rather bound by code. So here, for example, case of liability for personal injury. Okay, let's assume that we were in Quebec, you walked up my steps, you fell, you slipped, you sued me. Well, what the court would do in Quebec is they would look at the civil code and they look at section 1457 in particular. And it says every person has a duty to abide by the rules of conduct which lie upon him according to the circumstances, usage or law, so as not to cause injury to another. Now, that's not all of section 1457. It goes on and on. If you want to look it up on the internet, you can see that it goes on and on and on and on. But the fact of the matter is, just to illustrate it, it does lay out what the responsibilities are. The judge will look at that and say, okay, it's Paul's fault. Or, okay, it's not Paul's fault. So effectively, the judge will read the rules, look at this case, see how the rules apply to that case, and make a decision based on that. That's how civil code works. Pretty straightforward. Doesn't care what happened to anyone else. What we're doing is looking at each case independently. So the civil code, I say, the focus is on formal written laws. Judges decide cases primarily based on the applicable code. Juries are not generally involved in Quebec rules. Judges may refer to prior court decisions, but they're not bound by it. Nothing like that. So they, you know, the judges have a lot of authority in that environment. The good thing is that's all we're going to look at the civil code in this course. As we're concerned, we're in English Canada. English Canada uses common law. Our focus, common law. Okay? So common law is based on the British tradition. And is a system used by all of Canada's English-speaking provinces and territories. So common law is what we call judge-made law because current decisions are based on previous judgments, based on precedents or stare decisis, as I already said. Under common law, judges are bound to follow precedent cases if the decision made by the higher court in the same jurisdiction or if the case was based on similar facts. So what does that mean? Well, if we think about courts in Canada, there are what are called levels to the courts. The courts have lower level courts right up to higher level courts. The lower level court, for example, would be the court that you go to first. So you slipped and fell on my step. You're going to bring it to court here in Clarenville, and that's just the court of original hearing. Okay? Let's assume that the decision that that court brings, I would say, is the judge made a mistake. The judge ruled it wrong. The facts weren't all presented. Something happened. I can do what's called an appeal of that decision, because if I've been one found guilty, I can challenge that decision of the court. So I got to have a basis for the challenge, though. Some legal mistake had to be made. I just can't say I don't like the decision. You know, I got to have some basis of that. So if there is a basis of that, what can happen is that it will go to a higher level court. The higher level court is called the Court of Appeal. And the Court of Appeal looks at the facts of the case and determines whether or not the judge made a correct decision based on the information if some mistake was made. And that appeal court has a right to overrule the first court. Okay. So this is provincial now. This is a provincial jurisdiction court. So effectively, we can march our way up through the court system. There are several levels of court using this appeal process. If the court decision, and you slipping and falling on my step would not be a good example of this, but let's find a decision. Let's think about a decision that has broader implications. Okay, you came to me for a job. And I didn't hire you. Okay, you had all the qualifications. You scored really well. And you think that I didn't hire you for some reason. And let's assume the reason was that you have a hearing impairment. Okay? You're going to look at, you and your lawyer will look at that and say that that's not right. Your ability to hear is not going to have any impact on your ability to do the job. And you take it to court. And you lose the case. You lose the case, you suggest the judge made a mistake, you appeal it, you bring it to a higher level court. That court looks at it, and that court, again, a provincial court, will look at it and say, yeah, the judge made a mistake, we'll overturn the decision, or agree with you, or agree with the original court and say, forget it. If you believe, and if your lawyer believes that the decision that you reach in this case will have an impact on many other people across Canada, in this case, discrimination based on hearing impairment, okay? You could make a strong case that that will have an impact for other people across Canada. And in fact, I'm speaking of a true case that came out of Clarenville back 30 years ago, where a gentleman applied for a job with the Canadian Coast Guard. He had a hearing impairment. He was denied the job, and he brought it through the court system. He was found, he lost the case at all levels of the provincial court system. But his lawyers said, you know, this case has implications for people right across Canada. And the way our court system is set up is that there is a court, a federal court, called the Supreme Court of Canada. And what the Supreme Court of Canada does is it rules on cases like this that have national implications or implications for society as a large. If you can convince that court, the Supreme Court of Canada, they pick and choose their cases. If you can convince them that your case has significant implications nationally, they will take your case and they will hear it again. And in the case of this particular case that happened here in Clarenville, it went to the Supreme Court of Canada and the person won. And as a result, the legal system of hiring people and the cases for discrimination has changed the rules in Canada. You know, so the idea of the court system is that it's designed so that people get fair hearing. And so even though judges are based on precedent, there is an appealing process. And as I say, the Supreme Court of Canada will make an ultimate decision if the case has national implications. And we'll look at, as we go along, we'll look at this issue of what happened to the Supreme Court and things like that. Any questions?
That whole situation sounds weird to me because I would imagine good hearing is kind of needed for something like Coast Guard duty.
Yes, it is, and that is something actually that the court had to deal with. Oh, I'm getting some feedback. You just turn off you just mute your mic because I can hear myself. All right. And that's very true. That you could argue that this is questionable, but what has happened over a course of time, and when we look at the Charter of Rights and Freedoms, if you do human resource management, we'll call it, as you move along through your program, you'll find that that basic question that you pose has really been asked a lot. Say, well, how far is this going to go? How can you prove that hearing is important or not important? And over the course of several court cases that have dealt with this issue, and this is where the courts come in, because someone's going to argue, well, gee whiz, hearing is important. Hearing is important. The question is, how important? And what the courts have ruled, generally, this is not specifically in this case, is that it is the employer's problem to prove that it is important, meaning that the Canadian Coast Guard had to prove to the federal government or the federal court, that hearing, this discrimination based on we didn't hire you because you couldn't hear well in one ear, was proof that was reason enough, let's call it, to not hire. And the court ruled against the Coast Guard. And generally, in Canada now, with since 1982 to now, so do the math on that, that's almost 40 years. Over the course of 40 years of history of the Canadian Charter of Rights and Freedoms, employers have the standard of which employers have to pass in order to prove that something is mandatory, being able to hear or being able to walk or being able to, that bar has gotten higher and higher and higher and higher and higher. So employers have to prove that they're not discriminating by saying, well, you got to be able to hear or something like that. It's caused a lot of grief for employers. But in the meantime, the Charter of Rights and Freedoms, which I'll get into in a few minutes, really has been focused on individual rights as opposed to employer rights. So you got to think now, the primary focus, and we've agreed in Canada that the rights of the individuals are paramount. And that has caused some grief for employers. Anyway, so this common law thing is the basis on which we have our rules in Canada. So decisions are made based on previous decisions. One of the problems with this previous decisions thing is, let's assume that over the course of 100 years, decisions were made in the past that were blatantly unacceptable now. Let's say, for example, women were traditionally not hired for whatever. And the court system 100 years ago looked at decisions and said, oh yeah, that's fine. Well, women are not people. They're not defined as people. We don't have to hire them. How does the court system change over time if stare decisis is in place? If a judge is forced to make decisions based on previous decisions, and if those previous decisions are obsolete, how do we make change? And that's always been a challenge. That has always been a challenge with the stare decisis system. Stare decisis, though, basically says that in order to get around this problem or help get around this problem, it has to pass a couple of tests. First of all, in order to be able to base decisions on previous decisions, courts are only bound on that if they're a lower level court. Okay? What that means is, if I'm a judge in a low level court and I make a decision, and here's my ruling, and then if it gets appealed to a higher level court, the higher level court doesn't have to follow my ruling because I'm a lower level court. So stare decisis doesn't necessarily apply as you go higher. It does, however, if that higher level court made a decision and I'm at the lower level court, I have to follow it. So stare decisis only works one way. Higher level courts do not have to follow previous decisions of lower level courts or courts in different jurisdictions. So higher level courts are there in order to be that, I'll call it, it's like having a relief valve. okay, to allow changes to be made. So changes are usually made in the Supreme Court of Canada or high-level courts, not in low-level courts. Okay, so ultimately though, no matter what the rules are, whatever, it is our duly elected government's right to make rules. Okay, so we elect a government, and they have the legislative authority to make rules. And these rules are called statutes. So government-made laws are paramount, meaning that the people, we the people, the rip off the American Constitution, make the decisions about what happens in our world. So our duly elected government can make rules that override court decisions, and we'll look at that in the Constitution. We won't look at it today, but we'll see an example of that in the Constitution 1982. So effectively, the court, let's assume that the Court of Canada makes a decision, Supreme Court of Canada comes down with a decision to say abortion is legal in Canada. Okay, now that is not really business law, but it was a case where the Supreme Court of Canada said abortion is legal. It is the right of government to make it illegal. So a duly elected government could make it illegal. And there's been a lot of debate over the last number of years about whether more conservative governments would limit women's rights to abortion through legislation. So it is parliamentary supremacy is important because we live in a democracy and the people can choose. Now you say, well, I don't like the fact that our government would make abortions illegal. Okay. Well, what is the relief valve for that? If a stupid government makes a stupid rule that you don't like, your goal in the next 4 years is to unelect them and elect somebody else who will change the rule again, So this is how we get around the problems of bad government decisions. If you don't like the government, throw them out next time. This is why it's so important for people to vote. That's part of our system. But we can't have judges who are unelected officials making rules. So government ultimately has the power to make the rules. But we also run into the problem, like in every government, of something called the tyranny of the majority. So let's assume a majority of Canadians vote for a government that wants to ban abortion. But there's a lot of people out there who have very legitimate reasons to think that that's a rule that shouldn't exist. And again, our system is geared up, even though it's not fast. People say, I don't like the fact that I got to wait 4 years to change this. But the fact of the matter is that our system is geared up to make those changes over time. Okay, so government ultimately has the power to do what it does within limits. And when we look at the Constitution, we'll look at within limits. We looked at this idea of the other major source of law besides government is previous judgments. Courts will make decisions on things based on previous judgments, and that effectively is going to help create the base of law in Canada. As thousands of decisions are reached, the decisions will be, the judges will make these decisions based on a series of facts and looking at previous decisions. And if, as it moves up through the court system, the decisions will percolate to be good because of the way that our court system is set up, in that if a bad decision is made because of an error or something like that, and move up to the next level of court, and that can override the first.